think we have a full house today. So I'm here, Terrence Bond.
Present.
Phil Cabucci.
Present.
Ron Hogan.
Present.
Whitney Kimmerling.
Present.
Mike Loico.
Present.
Sean Parker.
Present.
Wow, the gang is all here. Okay, great. Mac, take it away.
Good afternoon, ladies and gentlemen. The Metropolitan Short-Term Rental Board of Appeals is now in session for its regularly scheduled meeting of March 30th, 2022. I am Bonnie McBroom. I'm the short-term rental chief for the Metro Codes Department, and I will be presenting the cases for the board for review in today's public hearing. At this time, I would like to ask everyone to either turn off their cell phones or put them on silence as to not disrupt today's meeting. The procedure will be to introduce the case record. At the conclusion of our presentation, the appellant will present their case to the board along with any person in support. If there is, if there's opposition to the case, the board will then hear from those parties. After the opposition has presented their testimony, the appellant will have a period for rebuttal. The board, in their rules, provides the appellant in cases without opposition 5 minutes for the appellant to present their case. In the contested case, the board provides 10 minutes for each side to present their testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some of their allotted 10 minutes for the rebuttal. The Metro Code requires that these proceedings are taped. Therefore, it is imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted that if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of show cause hearing. The board will go through all the cases set for public hearing today. After each case, the board will discuss and vote on that case. The board is vested with the power to act on these cases before us today under the following provisions as outlined in the Metropolitan Code Section 6.28.035. The code requires 4 members of the 7-member board to be present to constitute a quorum. The code also requires 4 affirmative votes to grant your application. In the event that there are only 4 members present and there are not 4 affirmative votes, the cases will be rescheduled for the next available public hearing. In the event that there are 5 or more members present and there are not 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be denied by operation of law. The appellant or any aggrieved party owner may request the rehearing within 60 days of the public hearing. Further, the appellant or any aggrieved property owner may also appeal the board's decision to the Chancery Court within the same 60-day period. After that time has elapsed, the board's decision becomes final and no further action can be taken. If you are an appellant and your case is granted, it is necessary for you to obtain the permit for which you have applied, and it should be noted that the permit must be obtained within 2 years for the board approval to remain valid. I submit that all cases have been filed in proper order. All appellants have been notified by certified mail as required by the code. All affected property owners have been notified, and the legal ad has been published in the Tennessean as required by the code. At this time, we see if we have any elected officials that wish to speak before the board. Seeing none, we will move on to the first case. This is case 2022-008, 1029 Chatham Place. This is governed by BL 2017-608, and the effective date of which is 2/2/18. There's a 1-year wait for advertising and operating with an expired permit, and the board has discretion to reduce the 1-year wait period. June 22nd of 2018, the Airbnb website ad was posted. July 31st of 2018, owner-occupied permit application was initiated, and August 1st of 2018, the VRBO advertisement was posted. On August 8th of 2018, an owner-occupied permit was issued. November 5th of 2018, the Hub complaint alleging, excuse me, I'm on the wrong
Can-
page. I
Can we
apologize.
just double check what, we seem to have a discrepancy
Yeah, I'm
between what's
sorry,
on the
I had the
screen.
wrong case, I apologize.
No problem.
All right, 2022-001, 119 A and B Elmhurst Avenue. This is governed by BL 2020-187, and the board has no discretion to lessen the one-year prohibition to apply for the short-term rental permit. In this case, the decision of the board is whether or not the zoning administrator erred in denying the permit based on the evidence that the property was advertised and operated as a short-term rental prior to obtaining the permit. April 15th, 2020, Unit A was cited for permit number not displayed. Unit B was cited for advertising excess bedrooms and permit number not displayed. Both violation notices were sent by Inspector John Feltz, and the website ads were corrected within the remedial time period, and the cases were closed. On August the 12th of 2021, the properties were purchased by YBC Investments from Momo Real Estate Investments Incorporated. The former owner had multifamily STRP permits for both units A and B. On October the 20th of 2021, permit applications were filed on both units. The review of the host compliance tracking for the website ads for the properties found that the short-term rental properties at both units had continued to operate after the properties were sold and before the new permit applications were filed. The 6 ads that remained posted listed the previous owner, Momo, as the host. However, there are 3 Airbnb ads that list Julian as the co-host, and Julian Bucci Forte is named as the contact on the permit applications for both units and as the appellant's representative on the short-term rental appeals board profile page. On October 26th of 2021, the STR board appeal was filed. The appeal was originally set to be heard on January 26th of 2022 appeal board meeting. There were 9 website advertisements. When I checked the status of the ads on December the 20th of 2021, there were 6 advertisements posted, each with a 30-night minimum stay, and in the ad description, and the calendars required a 31-night minimum stay. The 3 ads had been removed a few months prior to the sale of the properties. There were 5 verifiable documented stays after the properties were sold. On March the 16th of 2022, I checked the status of the ads, and all ads had been removed December the 30th of 2021. There were no new documented stays, and there were no documented complaints on the host compliance hotline or with the Metro Hub.
Before we hear from the appellant, can I just check in with you, Mr. McBroom, for a couple of clarifications?
Yes, ma'am.
I should remember, because it was only 2 months ago, but why was it that we didn't hear the case in January?
I believe, if memory serves, the appellant did not show.
Did not appear. Okay, that was one. And then, so from a short-term rental incident or stay, the most recent one that we have is before December 20th of 2021, because they had moved to a 30-day stay, which should have been a 31-day stay, but is that correct? We don't have any documented weekend stays or short-term stays after October 26th?
No, ma'am, we do not.
Okay, super, okay. So who do we have with us today representing this property and this appeal?
Good afternoon. My name is Griffin Dunn. I'm an attorney in Nashville, also Julian Bucci-Forte is also here next to me.
Have a seat, please.
Yeah, thank you so much.
And I'm sorry, if we could start over, have a seat. And I should have given this housekeeping instruction at the start, so my fault. Anyone who wishes to speak, you're going to press the button on that microphone in order to open recording. Please press it just once, and that goes to everyone on the board too. We have a problem with sometimes if it's pressed twice, it'll freeze the whole system. So once deliberately to turn it on, once deliberately to turn it off. And if it starts blinking red, just give me the high sign and we can reset it. So housekeeping matter. And then anyone who approaches, please, once you have opened the microphone, give us your name and your address for the record. So if we could open the mic and start over, thanks.
Griffin Dunham, counsel for the appellant in this matter. Name is spelled Griffin. Last name is Dunham.
And could you tell us about the situation here? And
Yeah.
keep in mind the 5 minutes. Do we have opposition here today for this case? Anyone here in the room wishing to speak on this case? Okay, so your time is limited to, is it 5 minutes apiece? 5 minutes total, so keep that in mind.
A quick point of clarification. Yes. At the prior hearing, the appellant was prepared to attend. However, some of the notices were not circulated prior to,
Okay.
So there wasn't enough time. That's why the hearing got. I do have two affidavits, both of them signed by Mr. Buccifotre regarding the certificates with respect to the notices and the signs that were being posted.
Very good, thank you.
And brief context, I know time is limited, so I'll try to speak fast, but not too fast. Mr. Buccifotre has certainly been involved with the properties, and this is prior to the closing on August the 14th of 2021. Prior to August 14th of 2021, the properties we're talking about units A and B at 119 Elmhurst. They were owned by a company called Momo Real Estate Investments. Mm-hmm. Prior to the closing, Momo had contracted with Airbnb and also contracted with third parties in order to use the property as a short-term rental. And all of the rental funds were received by Airbnb prior to closing for the benefit of Momo Real Estate Investments. At the time of closing, these were on the books, however, the guest hadn't arrived. Prior to closing also, Mr. Buccifotre, in connection with representing the future owners of the property going forward, he had reached out and they had established a dialogue, and he thought it was interest of his client's interest to reach out to Momo Real Estate Investments to figure out what the property's profile was and basically conduct due diligence prior to closing. So he reached out to Momo and became a co-host. There was no contract between Mr. Buccifotre and Momo. His co-host status was because he was an administrator who had rights to be able to look at the income, the frequency by which these properties were being rented. And so there was no contract between Mr. Buccifotre and Momo. However, he was serving in the capacity of helping the buyers conduct their diligence. After the closing of the property, there was no advertising whatsoever by the appellant. There was no short-term rental in any respects by the appellant, and I don't believe that that's been alleged. Every one of the 5 listings that's at issue was a result of Momo's contract with Airbnb and tenants prior to the closing of the property. I wanted to make sure that all the parties were aware of that. I believe that in the document that we have that's up on the screen right now, that appeared to be somewhat persuasive to the administrator when he states below the October 20th, 2021, that the 3 Airbnb ads listed Julian as the co-host. So the buyer wasn't an extension of the prior owner, and there was no privity, there was no relationship or affiliation between prior owner and current owner. Current owner had a tough decision to make at the time. One, I think that pleading ignorance of the law is no excuse, so I won't try to do it here, but there were existing contracts with parties who were going to be leasing the property. Those parties allegedly had a leasehold interest in the property, and since they weren't going to be involved in the operation of those Airbnbs, and there was no right between the purchaser and Airbnb or Momo to receive any of the rents at the time of closing, they basically preserved status quo. That's what happened here. And Mr. Buccifotre, as an owner of Airbnb, has 33 properties that he manages, was wanting to make sure that all safety protocols were being followed and that the property was both secure and was in a state that would be in compliance with the Airbnb rules, even though it was Momo who was on the hook and they were divesting themselves of ownership of the property. I understand that the burden here is on the administrator. So to the extent that that decision was based on Mr. Bucciafrotre's his affiliation with both the prior owner and the current owner, we would certainly contest that that relationship is somehow dispositive on the issue of whether or not the current owners were truly operating the property, or were they just effectively permitting the prior owner to collect the rents and to operate. I think one of the difficult challenges here is that your hands are tied. If you decide that the administrator did not make an error or did not come to some arbitrary decision, then there is no possibility for granting any variances. There's certainly not a possibility for reducing the suspension. So I think one of the difficulties here is if we look at the definitions. First of all, this isn't something that is going to be affecting people long term. We have an issue here where it's a rare situation where a owner takes over and then still allows a prior owner's privity to remain in existence. And so if you look at the definitions, we obviously have the Code of Ordinances, and that's been to some extent superseded by the statute because the statute also has a definition here that is instructive, obviously talking about 13-7-602. If you look at 6.28.030, the Code of Ordinances states that a short-term rental property is one that's a residential dwelling unit, not owner-occupied, containing not more than 4 sleeping rooms, that is used and or advertised through an online marketplace for rent for transient occupancy by guest. It's passive voice, so unfortunately it's not perfect, but is used for transient occupancy of a guest or for rent for transient occupancy of guests. And so the first question is, okay, so it wasn't used for rent, at least by the current appellant, because the appellant had no right to any rent. That was Momo. And is my time up?
I believe your time is up, sir.
Okay, I apologize.
Quite all right.
But I do have an opportunity for rebuttal in the event that anything else is said, or is my time limited here?
Your time was limited to the 5 minutes you just used. However, there will very likely be questions from my fellow board members which may allow you to elaborate further.
Perfect.
So, I have a very simple question. What was the sale date of the property?
August 14th, 2021.
Anyone else?
And that was when, excuse me, that was when title passed to Mr. Bucciafrotre.
No, that was when title passed to YCB Investments. Mr. Bucciafrotre was just an agent for
Gotcha.
the purchaser for applying for the permit.
Okay.
Thank you.
But in terms of the person on the hook for the violation, that's when title passed to that person.
Correct, sir.
Okay, excellent.
How many other short-term rentals does YCB Investments have in Nashville?
In Nashville, yeah, it's zero.
Okay. You said something earlier about
33
30-something
properties.
short-term rentals, or those in other
Oh,
locations?
CareBnB. So Mr. Bucciafrotre owns a company called CareBnB, and in that capacity as the principal of that company, he manages 33 properties within Nashville and has 2 of his own personally. And so YCB wanted to make sure that going forward, there was always going to be compliance, and Mr. Bucciafrotre has a good reputation, no complaints, no infractions, no citations with any of the 33 ever. And so they wanted him to be managing the properties going forward. And that's why he reached out to Momo to make sure that the buyers were acquiring what they thought they were acquiring.
And if I can trouble you to ask, YCB, do they own Airbnbs or similar short-term rentals in other markets
No.
outside of the Nashville area?
No.
Okay. Anyone else? Okay, if there are no more questions, I'm going to, Phil,
Sorry.
go.
I just have a quick point of clarity to make sure I'm understanding this correctly. So, Mr. Bucciafrotre, you work for or are connected to Momo in some capacity as well?
Julian Bucciafrotre, 1012 North 2nd Street. No, I don't have any affiliation with Momo Investments. The relationship was just pretty much due diligence for my clients, which are YCB Investments.
Thank you.
Thank you.
As part of that due diligence, and in that you manage 32 other properties, did you ever advise them that on the date of sale, an Airbnb or a short-term rental permit is canceled?
At that time, I wasn't completely aware of the situation myself in terms of, it was the first time I've encountered the sale and subsequent taking over of the new owners. So I honestly hadn't been through that scenario before.
Very good. Okay, anyone has any more questions? No? Okay, I'm going to call the public hearing closed. Only if we reopen the public hearing will you have another opportunity to speak. So if you want to stand by, just in case there are any questions that come up in our deliberations. But for now, if you could just close the mics and consider the public hearing closed. And we're going to debate amongst ourselves.
Thank you, everyone, for your time.
I mean, our hands are tied.
Yeah,
here,
yeah.
Because we can't reduce the time period.
Right.
But the permit is canceled.
Yeah.
At the time that it passes. And we have somebody that's managing 30-something other Airbnbs.
Hmm.
I don't think there was an error. in
No.
that.
And I
Ms.
think
Kimmerling.
notwithstanding the verbal agreement between YCB and Momo,
Yeah.
as to transitional matters, I just don't think that has any bearing on whether or
Yeah.
not there was operation.
That was not of any interest to me. I completely understand that there was due diligence in trying to have a smooth transition.
Right.
But the most basic piece of transition would be, we need a permit for this property, which is being canceled the day that the
Yeah.
sale goes through. It is cut and dry,
Yeah.
August 14th. And the governing legislation or the governing ordinance at the time leaves no room for us to make any adjustments. And I wouldn't see any need to, even if it did.
Yeah, I mean, we've seen some interesting cases at BZA and here where, there's a property is placed into a estate planning vehicle or, something that, or divorce, that might not, you could make a really solid argument that doesn't construe a transfer. And I think that we've sort of adjusted the interpretation at the zoning administrator level for cases like that. But I mean, this is two corporate entities, very clearly property changes hands. Either advertising or operating without a permit is expressly prohibited in the code. So I don't see any room to come up with a way that the zoning administrator erred on this one. Well, I'll move that.
I just look at it from the standpoint of the ownership question is, set that over to the side. It's, did they operate without a permit? And the administrator, got them for that.
Yeah.
And I don't see how you can say the ownership really doesn't matter one way or another. Unfortunately.
Well, then I guess I'll make a motion that we find that the zoning administrator did not err. Do we need anything else in that motion, legal? All right, I'll make a motion that the zoning administrator did not err in this case.
Second.
Very good. Can we see a show of hands and aye if you support this motion?
Aye.
Aye.
It's unanimous. So unfortunately, there won't be any relief granted on this case. Oh, please go right ahead. No, I'm sorry, no, I'm just kidding. Thanks so much for your time today. Appreciate it. Okay.
All right, our next case is 2022-008. Is the appellant present for this case? That's 1029 Chatham Place. Is there any opposition present? Seeing none. The governing ordinance for this one is BL 2017-608, and the effective date is 2/2/18. A one-year wait for advertising and operating with an expired permit, but the board does have discretion to reduce the one-year wait period. On June the 22nd of 2018, Airbnb website ad was posted. On July 31st of 2018, the owner-occupied permit application was initiated. August 1st, VRB of 2018, the VRBO website advertisement was posted. August the 8th of 2018, owner-occupied permit was issued. November the 5th of 2018, a hub complaint came in alleging that the owners lived in New York City and New York State. On March the 6th, an Airbnb website advertisement was posted. On May the 6th of 2019, a hub complained alleging the owners lived in New York again. On May the 16th of 2019, a hotline complained alleging that the website advertisements for the short-term rental property were advertising excess occupancy, excess bedrooms, and permit number not displayed. I investigated the complaint and sent a notice of violation for advertising excess occupancy, which was 23, excess bedrooms, for serving food, and for serving alcohol. The advertisements were corrected within the remedial time period and the case was closed. On June the 1st of 2019, a hotline complaint for the not the owner's principal or primary residence. On June the 18th of 2019, the permit renewal fee was paid. On July the 26th of 2019, a warrant was issued for operating a not owner-occupied STRP without a not owner-occupied permit. The warrant was served at 247 West 46th Street, apartment 3804 in New York City. The case was adjudicated, and the ruling was for the defendant. The case was appealed, and the appeal was dismissed. On August the 8th of 2019, the permit was renewed. On April 13th of 2020, a notice of violation was sent by Inspector John Feltz for advertising excess occupancy. This would have caused a warrant to be requested for a repeat offense, but the courts were closed due to COVID-19, and the advertisements were corrected again within the remedial time period, and the case was closed. On July the 20th of 2020, the permit was renewed. August the 8th of 2021, the permit expired. August 2021, 4 documented stays. August 21 of 2021, the Flipkey website advertisement was posted. On September 21st, September of 2021, there were 3 documented stays. And October 18th of 2021, the address was on the monthly list for properties advertising and operating without a permit or with an expired permit provided by Metro Government's compliance contractor, Granicus Host Compliance, for follow-up investigation. The notice of violation was sent by Inspector John Feltz for advertising and operating with an expired permit. In October 2021, there were 4 documented stays. November the 5th of 2021, the BO website was removed. On November the 8th of 2021, a complaint was phoned in to the Codes Department alleging that the guests were creating unruly behavior toward neighbors. Same date, Flipkey advertisement was removed. On November the 18th of 2021, the website advertisements had been removed and the case was closed. In January the 5th of 2022, Short-Term Rental Board appeal was filed. Both Airbnb ads were removed, and there were 11 documented stays after the permit expired, none of which occurred after the remedial time period. March the 2nd of 2022, both Airbnb advertisements were reposted with a 30-night minimum stay.
Good. Okay. Does anyone have any questions for Metro before we get started?
I have a question that says the permit expired. Did they not reapply? Has there been a reapplication?
No, sir, there was no record of reapplying or of renewal.
If there's no permit, if they're not in a permit, how can you appeal? What are you appealing?
Well, they're appealing. For the board has the discretion to lessen the 1-year waiting period for them to be able to reapply for a permit, which they currently are serving due to the fact that the permit expired, given that it's governed by BL 2017-608, which allows the board discretion to lessen that period of time.
Thank you.
To that end, why don't we have Ms. Lowe and Mr. Klein come forward, and we'll talk this out. Good afternoon, folks. So you heard our housekeeping announcement about how to manage the microphone. I won't bore you with that again. But we are going to be strict on time, so I'll try to give you a heads up when we're approaching the end. How's that? Great.
Thank you, Chairwoman. Seth Klein, on behalf of the appellant, Annette Lowe. My address is 1015 Fatherland Street, Unit 205, Nashville, Tennessee, 37206. Points of clarification on Mr. Bonnell's fact presentation. The main point being that an appeal for this matter was actually filed in November. And I guess for Chairwoman, if I can, for a procedural issue, the last time we had a hearing last month on this matter, Mr. Kabuchi was going to have to recuse himself for a conflict of interest.
Absolutely, and I apologize, I should have said that straight up, he will again.
Okay.
And that was the issue last time the appellant did appear, or at least her representative did appear, and, you know, none of you guys were here. So we had a very, very small crew, and we couldn't hear the case. So, and I apologize, we promised we'd see you first today. We got our signals crossed, but
No problem.
Madam Chair,
second isn't bad.
Madam Chair, can Mr. Kabuchi state that for the record himself?
Oh, yeah.
I will be recusing myself from this case.
Thank you, Mr. Kabuchi.
And I'll add some time back on, because that was my fault. So
Thank you,
please go ahead.
Chairwoman. So, point of clarification, this matter was actually, an appeal was filed for this in November of 2021, November 17th to be exact. There, from what I understood, Ms. Debbie Lifshee had retired, and there was some issues with the Metro Codes Department on who is handling these matters. After getting in touch with Jessica Shepard, Joey Hargis, and David Brabett, they informed me that the appeal had not been processed, and so that is the result of us being pushed to February and now March. So Ms. Lowe has been serving an injunction since that time with regard to operating without a permit. There is no argument or doubt that Ms. Lowe operated without a permit. I will not challenge that the zoning administrator erred in that regard. And Mr. Hogan, to your point, what am I appealing? I'm appealing to the right to hopefully reduce this permit from 1 year to 6 months to be with the start date effective on the date that the last stay occurred, which I think from my previous experience before the board is the standard that they've used in the past, but I may be wrong. In addition to that, I have letters for the board. I only have 7 copies. I apologize, counsel, I did not bring 8. But I have copies of letters from the board of, let's see, 1, 2, 3, 4. 16 neighbors from around Miss Lowe, and I know that there was some record of prior complaints and things of that nature, and also an allegation that Miss Lowe did not live at the property. This is Miss Lowe's primary residence. She does live here full-time. She does not live in New York, and outside of that, those were the only facts I wanted to clear up. But to the point, again, this is strictly an appeal, again, not challenging that the zoning examiner erred, but strictly to reduce or hopefully attempt to reduce the injunction from 1 year to 6 months. In the alternative, I would propose a novel argument that I don't think has been before the board thus far, and that if the standard is should the board determine that they do not want to reduce the 1 year injunction to 6 months, then in the alternative, I would plead that the law at the time this permit was applied for and approved did not establish or otherwise delineate a short-term rental board. All appeals were heard before the BZA. So, in the instance that this board determines that Ms. Lowe is not eligible for a reduction of a 1 year injunction, my alternative argument would be a request for rehearing before the BZA pursuant to the laws that were in effect at the time the permit was issued.
We've got about 1 minute left. If you'd like to share that time with Ms. Lowe, please go right ahead.
Just for the record and to cite the law, under Metro Code of Law 6.28.030.A.5.1.6.2, upon the determination that a zoning examiner administrator has determined that a short-term rental operator without a permit, that permit shall be 1 year. However, pursuant to 2017-608, there is a right of reduction by this board in the discretion or the governing body to reduce that permit from 1 year to 6 months. Pursuant to 2017-608, we would request that this board reduce the 1 year injunction from 1 year to 6 months. And Ms. Lowe, do you have any comments or anything that you would like to say? That'll be all for us. Councilwoman, or I'm sorry, Chairwoman, thank you.
Thank you very much. Questions?
I have a question. You did sort of touch on some of the complaints, the allegations of not being an owner-occupied unit as well. I think more concerning, there's sort of indications of like large parties happening there. There's a complaint, unruly behavior toward neighbors, which was phoned in after the permit had expired even. So, I mean, is there any explanation for that pattern there?
And Councilman Parker, I will let Ms. Lowe speak to that if she has any comments, but my initial response would be that there is no when a reservation is made on Airbnb, there's no background check. There's no, like, are you going to be unruly? Like, they agree to those terms. They agree to, use the property in a way that is residential in nature. And there's nothing in the ad that encourages it to be a party house or anything like that. Again, Miss Lowe lives here. This is her primary residence, so it's not like something that she wants to come back to and, have to apologize to her neighbors for the acts of a third party. But I think to impose some sort of standard of care on Miss Lowe as a result of these bad actors, I don't know what that looks like necessarily. But nonetheless, I do know that Miss Lowe has a responsible party that is within 25 miles of the, 25 miles of the property that can get to the property when needed, on call, pursuant to the law and pursuant to the conversations that this board has had previously, and that outside of following and otherwise adhering to the requirements for operating a short-term rental, I'm not sure how. I feel like it's too attenuated to hold Ms. Lowe accountable for somebody who comes here for a bachelor party or somebody who comes here for a bachelorette party. I don't think that there's any evidence or indication that she is otherwise influenced or caused those events to happen.
Annette Lowe, 1029 Cheatham Place, Nashville, Tennessee, 37205. Just to clarify, you're asking about the November 8th disturbance from someone neighbor calling. I was home and a neighbor called because I was doing yard work and they made a complaint. I don't know why they would do an Airbnb complaint because I called and said I'm doing yard work, and that was the complaint that is shown here, but I'm not sure why she called this number instead. So that was not a guess. I was home, I was there. There's no stay over there, it was home. And that neighbor even called me and said she made a complaint. So I know why that complaint happened, and timing didn't really work. And also, I don't provide any outdoor speakers or speakers at home or television or any sort outside, because I know that I treasure our neighbor and the peacefulness of it. So I just respect the neighborhood a lot, and I give in a lot for the neighborhood too, but I just very disappointed that. Yeah.
And Councilman Parker, if I can just piggyback off that slightly, in previous hearings we've had before this board, Ms. Broom has spoken about there were times when the complaint hotline or the call-in hotline for lodging complaints or issues within Metro, that number was one and the same. There were short-term rental board complaints that were getting called in on that number. There were other just various ordinance violations that were being called in. So, and I can't speak to the timing of that. Mr. McBroom will know that, I'm certain, but I would allege that if anything, given the nature of the complaint, as Ms. Lowe has testified to, or spoken to, rather, that would likely or could plausibly be a reason why this was on that short-term rental hotline number to start with, or whether or not that change had went on with regard to those complaints.
Mr. Klein, if I may, I just want to clarify something you said toward the end of your discussion. So it's your position that that neither local nor state codes impose upon homeowners a duty to not use their home in such a way that interferes with the quiet enjoyment of other property owners?
No, sir, Mr. Bond, that was not, no. What I'm saying is that I don't think that Ms. Lowe certainly has a duty to not interfere or otherwise infringe on somebody's quiet use and enjoyment to their property.
Right.
What I'm saying is that this permit itself is tied to Ms. Lowe, and Ms.
Right.
Lowe has not done anything to otherwise interfere, which could be arguably say that, well, she's operating an Airbnb and neighbors complained, right? That's the other side of that.
Right.
But she, in and of herself, is not a bad actor in this instance, and this permit is tied to her right to be able to operate a short-term rental.
Right.
So if this board determines that they will, reduce that injunction today, I think that Ms. Lowe understands that her ensuring the individuals that are booking the property continue to respect those around them and maintain that moving forward.
Right, because she has rules established. Like I looked at one of the pages, and it says, there are rules, one of which is no events, some other
Parties,
things, right? Some other things. So
Ms. Lowe has been our
position that those are sort of a separate. When she gets a permit, so she's kind of carved out from the obligation to. I guess I'm not understanding what position you're taking as far as that goes.
So
operating the property.
what I'm trying to articulate, and I apologize if I'm not doing it well, is that yes, as a property owner, Ms. Lowe has a duty of care that is established in Tennessee common law, case law, as you're very very well aware of. What I'm saying is that if she has not, in and of a sense, outside of operating on an expired permit, not done a bad act.
Yes, she
Now,
herself.
Sir?
She herself.
She herself, individually,
Correct.
yes. And this permit itself is related to Ms. Lowe. And it's her property right. It's her ability to be able to permit it to operate a short-term rental on this property.
Okay.
And so while, yes, there have been prior complaints, which, given that they've been adjudicated, ruled in her favor, appealed, dismissed at the circuit court level, it seems like that there was not enough proof to establish that.
Well, you said, when you say they, I only saw that the issue of whether or not this was an owner-occupied Airbnb, that was adjudicated. Were there other matters adjudicated that we're unaware of?
No, not to my knowledge.
Okay.
That's when I say they, I'm referring to the fact that advertisements were corrected within the remedial time, that any time that there was something requested of Ms. Lowe, if there was something that she needed to do, she affirmatively acted, that she was a good actor in this sense, and she was trying to be a respectful neighbor, that she, again, she did put in those rules. She did put explicitly no parties, no events, things like that in an attempt to be said good neighbor. So that, I hope that, Vice Chairman Bond, I hope that maybe paints the picture a little bit better on what I'm trying to convey.
I think I understand where you're coming from.
Any other questions?
Ms. Lowe, why didn't you renew the permit when it should have been renewed?
I'm a human and I forgot.
I'm sorry, you said you forgot? We're not able to hear you very well.
Yeah,
have to speak
I
up.
just forgot.
You just forgot. Okay.
And I tried to, when I saw the notice on the door, went back and it was 2 months late and I just forgot.
Any other questions?
I have a question for Metro. Do we know, are we able to determine the complaints that are filed through the hub system or whatever, do we know if they're filed by the same person? Or are they filed by multiple neighbors? Do we have that information?
That's dependent upon whether they wish to remain anonymous or not. And I apologize, I do not have copies of the complaints.
If there are no further questions, I'm going to consider the public hearing portion closed. If we reopen the public hearing, you'll be given another opportunity to speak. If we do not open the public hearing, there's no more opportunity to speak.
Thank you,
We
Chairwoman
understand?
Run.
Thank you.
Thank you.
Okay. While there's certainly interesting reading here about the multiple complaints about this not being an owner occupying, the owner occupied. Interesting reading here about apparently a successful delivery of a warrant to an address in New York City. To me, what strikes me about this case is this is an operator that's been in business since 2018. This is an operator who has kind of had 9 lives on issues. You know, the city has put a lot of resources into keeping this owner on the straight and narrow, you know, coming in for this complaint, coming in for that complaint, you know, excess bedrooms, serving food and alcohol, all of which is prohibited. And this is someone who's had an Airbnb since, or had a short-term rental, I should say, since 2018. This is the owner's responsibility to renew. There've been a lot of, I mean, I look at the 2021 and this looks like it could have gone south for this appellant. In 2020, and didn't. There was a notice of violation, would have been a warrant for a repeat offense, and only because the courts were closed was no further action taken. And yet the permit gets renewed afterwards. So it seems to me that there have been a lot of extra chances given, and so I'm just really not compelled to be lenient here.
As far as that owner-occupied piece of it's concerned, to me, there is a way, in some ways, I think you draw a line between, you know, July 2019 and August 2019 as to when things happen, because we don't have the details of that, and that was adjudicated by the circuit court, and I don't think we can base any of our opinions on any complaints related to owner occupancy.
Agreed.
I think those have to be off the table for our purposes.
Agreed.
You know, and then if you look, you've got 2 notice of violation after that time. The hub complaint, even if you take that out of, you know, the November 2021 hub complaint, even if you take that out of the equation, because it was when Ms. Lowe was at home doing yard work, according to her testimony today, you've still got 11, is it 11 stays? Post the time when the permit should have been renewed. Given the fact that it's been renewed previously, and as has been pointed out, that there have been multiple violations or quote-unquote 9 lives, I'm also not inclined to grant any further relief.
Nor am I. And also on the secondary question, I don't believe, I don't find that there's any merit to the suggestion in the alternative that this board would have the authority to issue relief, but wouldn't have the authority to do so if we, I'm sorry, I'm actually confusing myself. I don't find the second proposition regarding the board's lack of authority to actually hear the case in the event that we aren't willing to grant relief to be compelling.
Agreed. I don't think there is any supportive authority that makes that position persuasive, nor, while we're on that topic, I don't think there is any persuasive authority, and I am in no way persuaded that short-term rental operators have no duty of care.
Yeah, I'm
period.
struggling with that. I'm struggling with that one real hard.
Does not persuade me in the least.
No, yeah, that doesn't. I can't reconcile those things logically.
But I think that goes into the category of interesting reading too, in that it's not really why the appellant is before us today. The appellant is before us today because she was operating without a permit. This is an experienced operator
Right.
who has renewed permits in the past, and it's an experienced operator who's had a few run-ins is overstating it, but had a few issues in the past and has managed to, continue to operate. I feel like if you'd had issues in the past, you'd want to be as conscientious as possible about keeping everything organized and legit, right? So I think that's kind of where I come down.
For me, I agree. It comes down to operating without a permit. Personally, I think that the complaints in the past hold some weight, but less weight for me, because they were either dismissed or ruled in the defendant's favor or closed because of circumstances. So it is difficult for me to hold a lot of weight with them, although obviously the number of them does start to paint a little bit of a pattern. But there is the possibility that it is one upset neighbor that is continuously calling. So I'm not really sure how to exactly weigh that aspect.
I would like to, though, explore this idea that this was supposed to have been filed in November, but sort of lost in the shuffle with Debbie's retirement versus sticking with as far as I think we need to determine what date we're working
Right.
off of. And if that comes into play, I think that we need to pay some credence to that potentially.
Mike, just, if I may, I think if we're going to have that conversation, it would be important to understand what the date that Codes is working from is.
Yes.
Mr. McBroom, do you know, as of the determination of the zoning administrator now, what date they would be eligible to reapply?
Well, that's totally up to the board's discretion. We make recommendations about the first day of the month following the last day. So, say in this case, the last day occurred in October, then November of 2022 would be the date, but it also can be based upon the date of expiration. However, in general, if operation continues after the permit is expired, and that's the reason that they're appearing before you today and appealing, is the date of the last operation, the first day of the following month. But these are merely suggestions. The board has full discretion in this matter.
I'll say that just to follow up, if the appeal was meant to be filed in November, the advertisement was not removed until November 18th.
Council informed us that the appeal was filed November 17th, and then the ad was removed the 18th. So I think those are some safe dates to work from. So shall we have a motion? So we move.
Let's do some math first. Let's do some math first.
So the one-year waiting period, if we are to stick with the one-year waiting period, we would deem it, I believe, to begin on either the 17th or the 18th. The 17th, and that was the first date that any, proactive action was taken on behalf of the appellant. The 18th, which is the date, one could argue, of the last violation, in that advertising when you don't have a permit is a violation. So we could, if we're being strict, we could say the 18th instead.
I was actually thinking December 1st, and then if there's to be credit extended for the delay due to administrative things going on behind the scenes.
My inclination is typically we look at the last violation and go from there.
Okay.
So I would say the 17th date for me would be of not much consequence.
Okay.
The reason I brought it up before was if it was something that was going to be, if that date was going to be affected by, and we've
Right.
worked through all that
Right,
at this
right.
point.
So it sounds like we are okay with saying that November 17th of this year would be the date.
Yep.
Okay.
Yep.
So I think we'll need a pair of motions.
I don't believe we do need a pair of motions.
I think we need to actually, I do think we need to rule on yeah, the
Okay.
BZA request. So, given that, I move that we deny the request to transfer jurisdiction of this matter over to the BZA. And I'll further move that we allow the appellant to reapply for permitting on no earlier than November 17th, 2022.
Do we need two votes for that or one vote for that?
It's fine to have one, that can be a combined motion, that's fine.
Okay,
Seconded.
okay. Can I see a show of hands, all of those in support?
Clarification, did you say November 17 or December?
November 17th, my brain is not working.
Do you want me to restate or do you want to restate it?
Yeah, just for clarification purposes.
Sean, why don't you restate it so that we can trust the motion?
Board member,
right.
be quiet for a minute.
I'll restate that motion and move that this case not be transferred to BZA and that appellant is eligible to apply for a permit November 17th, 2022.
I second. Can I see a show of hands and a vote as to all those who support this motion?
Aye.
Aye.
Very good. Okay. Thanks so much for your time today, folks. We appreciate it.
Thank you.
Our next case is case 2022-012, 1019 Summit Avenue. Is the appellant, is there opposition present? Seeing none. This is governed by BL 2016-257, effective date September 21st, 2016. There's a one-year wait for advertising and operating with an expired permit, and the board does have discretion to reduce the one-year wait period. On October the 10th of 2016, a multifamily not-owner occupied permit application was initiated. On October the 17th of 2016, a not-owner occupied permit was issued. November 13th, 2016, an Airbnb advertisement was posted. October 17th of 2017, the permit was not renewed. And this is due to the fact that permits issued in 2015 and 2016, the renewal date auto-populated for 2 years. And unless it was manually corrected at the time of issue, then it ran for 2 years. Notification was not sent. There were a few permits during this time that were not corrected. September the 13th of 2018, the permit was renewed. On September the 24th of 2019, the permit was renewed. November the 19th of 2020, the permit was renewed. And October the 17th of 2021, the permit expired. There were 3 stays in November of 21, 2 in December of 21, and January 5th of 2022, the address was on the December 2021 list of short-term rental properties advertising and operating either without a permit or with an expired permit, provided by Metro compliance contractor, Gronicus Host Compliance, for follow-up by our team. Notice of violation was sent by Inspector John Phelps for advertising and operating with an expired permit. In January of 2022, there were 2 documented stays. January 19th of 2022, the advertisement and the ad calendar were changed to a 30-night minimum stay within the remedial time period, and the case was closed. January 27th of 2022, the short-term rental board appeal was filed. There were 7 documented stays after the permit expired. There were no documented stays after the remedial time period. The ad remained posted as of 3/17/22 with a 30-night minimum stay, and there have been no additional documented stays. There were no documented complaints in either the host compliant short-term rental hotline or the Metro Hub.
Very good, thank you. Any questions for Metro before we hear from the appellant? Come on up. Nope? Okay, very good. I won't bore you with all my instructions again. You know how that works? If you could give us your name and address and tell us about your situation.
Yeah, my name is Damani Maney, 5835 Woodland Hills Drive, Nashville 37211. Basically, my situation is fairly cut and dry. Just a mental error, just basically forgot to renew it, and by the time they alerted me, it was, I tried to remediate it, so, straighten it out. But as you can see, I've renewed my permit since 2016, pretty diligently on time, and I don't have any complaints. It's just a small 2-bed, 1-bath. Most people just come to lay their head. They're not coming to party there. And like I said, just a mental error on my part where I just totally forgot about it. It's no excuse there.
Sir, can you tell me, so in, January 5th, a notice was sent out by codes, and then did you receive that letter, and what'd you do once you got that letter?
Well, I'll be totally honest, I don't remember seeing that letter. Maybe until after they sent it, I don't check my mail every day.
Yeah, well, I guess my question is, how'd you become aware that the permit was expired?
I want to say I got the letter, but
Okay,
I didn't get it early enough to know to stop before I had the last 2
Gotcha.
stays.
Yes, sir. Thank you.
Okay.
Mr. Main, could I trouble you to ask, do you own any other short-term rentals, or do you manage any others?
No, that's my only one.
Okay, and this is a multifamily, is that right?
That's correct.
And do you live on the property as well?
I do not live on the property.
So do you rent just one part of it, or the whole thing?
So, just a quick history thing. Before I got this permit, I just wanted to test the Airbnb market out. I should have got the other 2, but I didn't because it's a 3-family apartment building. But I didn't. I just wanted to get the one to see if I wanted to do it, and then before I went back, all the rules changed, so I couldn't do a non-owner occupied at that point. So I only have one instead of the other 2. The other 2 are long-term rentals.
Very good. Okay, good information. Thank you.
Yep.
Anyone else have a question? Nope. Okay, I'm going to close the public hearing. We're going to discuss this amongst ourselves. You can return to your seat or stay there in case we have any other questions. Up to you. Thank you.
Can I ask one question, or is it?
Of course.
Closed? Okay.
No, you took much less than your 5 minutes, so you go for it.
Okay. So the only question that
Wait, I don't think it was officially closed. Or do I have to reopen?
If you haven't closed it, it's fine.
I didn't think I did, but in case I close the public hearing is deemed reopened. Go
Okay.
right ahead.
Just a real quick question, and I wasn't clear before because there's a lot of email communication. If I'm available, or if you guys would allow me to go back and reapply for a permit, is it going to be under the same non-owner occupied, or is it under the new rules that I will be considered? How does that work?
Excellent question that I don't have an answer for. Sean May.
I believe I've asked the zoning administrator this during proceedings before, and you would be eligible to reapply for the permit that you had before.
Okay.
Is that correct, Mr. McBroom?
Provided that the operation is not ceased for 30 consecutive months, the state law allows it to be grandfathered.
So even if we were to grant you 0 relief, after the year period, you would be eligible for that same type of permit because 30 months had not elapsed. I believe it's 30 months.
Yeah.
That's correct.
Yes, sir.
Makes sense. Thank you.
We're all good? Mm-hmm. The public hearing is now closed. What does everyone think?
I think there were a number of document stays after the permit expired. I think there's obviously some question as to when the appellant became aware of the notice of violation being issued, but I think given the history of operation, there should have been awareness that this was something that was not permitted. I think that the dates to reapply is probably January 1 of 2023.
I appreciate I appreciate his candor, that
Yeah.
he made a mistake. He simply forgot to renew it. I am encouraged by the timeline of when he believes he became aware in January and the remedial measures taken after that point. I'm encouraged by the fact that there are no complaints. He's got a great track record. In my opinion, I would be in favor of some relief from the one-year time period for Mr. Maney.
I do agree. I think in this case, 7 months, 1 month for each document stay after the expiration date would be acceptable.
How clever. I think that's an interesting way to look at it. I think too, I'm encouraged, I'm discouraged when you look at someone who's been a long-term operator. We count on the people who are long-term operators to get the job done, right? And it's an investment property. It's important to an investment property owner to stay on top of things. So in that way, I'm disappointed. At the same time, to know there are 2 long-term renters in that building and that we don't see any complaints, it's a good sign as to how things are being run, even though that's not really the issue before us. But it does give me, some hope. So, I agree that some relief is warranted, maybe not warranted, but palatable. I don't know, I like 7 months. But when would we go the 7 months from? From January 19th, which is when the ad was changed to 30 days? Or would we go for some, I don't want to be presumptuous, I thought it was a clever idea, but we could also reject Phil's clever idea and
You
say
absolutely
8 months.
I would say 7 months from the last document stay.
Well, the last document to stay was in January, but we don't know when. But we do know that the calendar.
7 months from the 19th.
Yeah, that's kind of what I was thinking.
So that would be August 19th. Okay.
Sean, what do you think?
Yeah, this is one where I'm generally going to, because there's, no documented complaints, because it appears that when the appellant became aware of their error, they took action to correct it, I'm going to be comfortable with anything in that 5 to 7, kind of middle of the road reduction range. I wouldn't support anything further. And I do think, again, when people are clearly taking action, once they realize they've made a simple mistake and we don't have a sort of laundry list of complaints documented, I'm inclined to, the main goal of the whole permitting process, in my view, and codes may differ on this, I'm speaking for myself, is to keep properties compliant broadly, and to keep people aware of the rules. And it seems like every other aspect, this one's been operating fine, so I'm comfortable with that degree of relief if someone wants to make the motion.
Okay. I will make a motion that we offer a reduction in the waiting period to 7 months, down from 12, allowing the appellant to reapply on August 17th or whatever the court.
19th.
I'm sorry, August 19th. Start over. Before we do that, is that a weekend day?
Well, it's always the next business day.
Okay. Thank you. Let's start over. Everyone's having a hard time with this today. So I move that we offer some relief to the 12-month waiting period, a 7-month waiting period starting from the date of the last documented violation, which was January 19th of this year, which would put the appellant at the first business day after August 19th of this year. Do I hear a second?
Second.
Can we see a show of hands, all that support the motion?
All right.
Okay, very good. The ayes have it. So you'll be eligible to reapply come whatever the business day is closest to August 19th of this year. Thanks so much for your time today. We appreciate it.
Our next case is 2022-014-1117 Wagner Court West Is the appellant present? Is there any opposition present? Seeing none. This is governed by BL 2017-608. The board has the discretion to lessen the one-year prohibition against applying for a short-term rental permit. On October 17th of 2019, the owner-occupied permit application was initiated. On August the 28th of 2019, the permit was issued. On November 1st of 2019, the VRBO website advertisement was posted. On November 2nd of 2019, the Airbnb website advertisement was posted. On October 28th of 2020, the permit was renewed. On October 1st of 2020, Airbnb website advertisement was removed. On October 29th of 2021, the permit expired. On November of 2021, there were 3 documented stays. January 5th of 2022, the address was on the December monthly list of properties advertising and operating without a permit or with an expired permit provided by Metro Government's compliance contractor, Granicus Host Compliance, for follow-up investigation. A notice of violation was sent by Inspector John Feltz for advertising and operating a short-term rental with an expired permit. The January 22nd of 2022, the VRBO website advertisement was removed within the remedial time period and the case was closed. On February 16th of 2022, the short-term rental board appeal was filed. There were 3 documented stays after the permit expired. There were no documented stays after the remedial time period. There were no documented complaints for the property in either the Metro Hub or with the host compliance hotline.
Very good. Any questions for Metro? Okay. Can we have the appellants come forward, please? Great. If you could open the microphone and state your name and address and tell us about your situation.
Hi, my name is Ayana Barkley. The property of, 1117 Wagner Court West, Nashville, Tennessee, 37214. So pretty much for
Sorry, is that your address? Where you live?
117 Wagner Court West?
Yes.
Yes.
Okay, it sounded
Okay.
like you were just telling us the address of the property, which we knew we need your address.
No,
Okay.
sorry.
Very
Yes,
good. Okay,
yes.
thank you.
So pretty much for my situation, when it comes to the permit, I did not, so when I first, sorry, I'm a little nervous.
You're fine.
I'm
Go
a
right
little
ahead.
nervous.
You're doing great.
Sorry. So pretty much, when I finally talked to codes, it wasn't necessarily a matter of forgetting, but when I talked to codes, they had informed me that they changed their renewal notification or their letters from mail to electronic. I am just conditioned to getting them in the mail. I did not get mine in the mail. I also did not receive it electronically. So when my first notification of my permit being expired was when I was told my permit is expired, and when I got that notification. I'm a STEM major. My mind is everywhere. I'm a student, and this is where I live, but this is also the way I'm able to go to school, as well as live in this place. So this was a creative way that me and my mom came up together to kind of, be able to fund these things. So yes, I am just here today to pretty much try to figure out if there's any way to right this wrong in a way. I have been good at renewing in the past, like you guys mentioned, no complaints. I'm definitely not going to make this mistake once again. Definitely reminders in my phone. Technology is useful, but yes, that is pretty much my situation. Is I just was not aware in November or October or November when it expired, end of October when it expired.
October 31st.
Yes.
October 28th.
Hi, I'm Sally Barkley. I'm her mom, and she is correct. This was a situation where we're trying to figure out a way for her to get her med degree and be able to make some money because with the year of COVID, she was doing so many labs via Zoom and all these different things, and the anxiety was through the roof, and we're just trying to figure out a way to make money where she was able to carry the load she was carrying. With that said, we also know that you have to have responsibilities, and so that's why I'm also listed as the manager to help her with her Airbnb and the communications and the check-in, check-out, cleanings, that kind of stuff. I do help her with that stuff, and I sell real estate, so I have a lot of, that knowledge as far as when those types of things go. When we got the notice, or when she got the notice, she called me crying. It was like mid-January, and the very next day I emailed John Felt on January 17th, and he emailed me back on the 18th and just told me to reach out to Robert Osborne. Reached out to him the very next day, and then they communicated back along with Leoncio, who said that at the very end of October, you guys switched from the mailing to the electronic version of notifications, and that he was aware that lots of people did not get a notice that year. Again, we know now, that it was definitely our responsibility, and we definitely relied way too much on that notice. But when he told us, he said, just go ahead and reapply immediately. So the very next day actually not the very next day, on January 22nd, I emailed Robert and talked to him about, he emailed me back and said that the grace period was gone and that I needed to reapply. And then I was going in for surgery on the 27th, so I made sure that we ran around and scrambled to get everything together. And on the 26th, we submitted for a new permit approval right before the next day of surgery. And then we got an email back from David, who was just like, I'm so sorry, but you're going to have to appeal this because you had the stays. Of course, we had the stays out of ignorance, and not an excuse, just those three. As soon as we were told it was taken down, it was righted as fast as we could. But David said that we could not, unless we appealed it, have any stays till December 1st of this year. But as she mentioned, this is how she lives, and this is how she pays for college and, her life. So that I think we're so nervous because so much hangs on this. Sorry.
We're out of time. No, you're fine. You're fine, but we're out of time for your 5 minutes. So let me open this up to questions. Anyone have a question for either of the Mrs. Barkley?
So when you first became aware that the permit had expired, did you have any already booked reservations at that point?
All of them were canceled. I have notifications showing that we immediately responded to VRBO and told them that we cannot have any stays until further notice. And you have to select it. And unfortunately, it's not even an option to say hey, we forgot to renew our permit. So we had to say that we were unable to, I can't remember. We had to pick another option, but we canceled them immediately. And I have proof of those.
Thank you.
Quick question. So is the permit displayed in the home? Or where do you keep it?
It's on all of our advertisements, and then it's in a file in my office in a little black divider thing.
Gotcha.
I bet you wish you put it on a bulletin board now.
Our thought was the safety thing. We didn't, when she's there, we don't want people to think there's people from in and out of town, because she does stay there, and then she lives with us. When people are there, she'll stay with us, and she has a couple girlfriends that live right around campus, so she'll stay with them sometimes. But we just felt initially as a mom, I didn't want it to be a safety thing and display it. But,
I do, correct me if I'm wrong, aren't they required to display it? No? In the house? I know it's supposed to be displayed on the advertising. This is kind of a side matter.
It is in the ordinance, but, and I can't say with a 100% assurity, but I'm 99% sure that by 608 it was included in the ordinance. Prior to that, some earlier iterations of the ordinance, I don't think included that.
But there would be no need to post it except for when people were there. Renters were there, right?
That's correct.
So, anyway, side issue. Anyone else have questions? Nope, okay, we're gonna, You sure?
Yep.
Okay, we're gonna close the public hearing. We're gonna close the public hearing and discuss this amongst ourselves. Thank you.
This doesn't seem very factually distinct from the last case that we heard. Sounds like there is, a history here of compliance in terms of not having complaints and otherwise responsible operation. There were a few stays, but nothing that was egregious, and certainly nothing that was after the appeal was filed.
I would say that in some ways, I do find this to be somewhat distinguishable from the previous case in the sense of she's only renewed this permit one other time.
Right.
She only had 3 stays. I think we had 11
Was
or
it
7 in the
just 7?
last.
Yes,
And at
7.
least, 4 or 5 renewals.
Yeah.
So I think you have a less experienced operator
Sure, certainly.
in this scenario that I think is distinguishable and notable for me.
Very good.
Yeah, I mean, we didn't ask the previous gentleman if what he did with pending stays, but, I mean, that's a pretty, affirmative step in the right direction for a host to take when they're become aware of
Yeah.
being out of compliance. So, and I know that probably comes with penalties as far as the platforms are concerned too.
Yeah.
So, I definitely consider that.
Gotta be strict sometimes. We have actually heard that too. We've actually had appellants who've told us,
Yeah.
well, I didn't cancel it because it's not fair to them. So it's, we've certainly seen people make other choices, is my point. So, well, what, does anyone have a proposal?
Well, if we follow the previous case, we would give them a 3-month.
Well, I think that's like today.
They would be opening up tomorrow.
I do think it is somewhat dangerous to start a precedent of
Yeah.
Right.
1 month per stay.
I agree.
think in the previous case, it happened that the two coincided, that was a reasonable amount of time. But I don't think we can set a precedent as a board that
Right.
it's 1 month.
I would, just to echo that, I mean, host compliance captures what it's able to capture.
Right.
A lot of this marketplace is gray market and black market as well. So,
Yeah.
we can't count on this being the number of actual documented stays in any given case.
True.
So I just wanted to echo that. In this case, I think that given the circumstances that we just highlighted and the similarity to the previous case, I think like 5 months would be appropriate. We're using odd numbers this time. So next month we'll use even numbers. I'm just kidding. But I think
Prime numbers 1 month.
yeah.
Right, yeah.
I think that
Visible by
I'd be comfortable with some degree of more relief than the previous case, but obviously not 12 months.
From what date are you proposing?
Generally, I think in the previous cases today, we've used, in a lot of cases in other meetings, we've used, the first affirmative action taken by the appellant, which in this case is
January the 22nd.
January 22, yes, of this year.
I don't know if I necessarily agree with that, because the affirmative action of them canceling their previous stays is not necessarily something that's noted here, but something that they did say that they did.
Well,
Right.
I think though, if you consider it the last infraction, the VRBO website ad advertising them as a short-term rental was up until January 22nd. So one might argue that January 22nd was the last day that a violation was made.
I think that's a reliable measure in these circumstances.
Agreed.
So, go ahead, Whitney.
I may be in the minority, but I would be in favor of something shorter than 5 months.
Okay.
I am as well.
What do you have in mind?
Well, if we're looking at January, I would say 4 months from January 22nd would be
I
my,
would second that.
I can live with that.
You can live with that, okay. You would second that? Yep. But would you like to make a motion to that effect?
Well, I was really hoping that Ms. Kimmerling would, but I can.
I make a motion that relief is granted to the extent that the appellant is able to reapply for a permit 4 months from January 22nd, 2022.
Very good. Can I see a show? Can I see a show of hands and a vote for those in support of that motion?
Aye.
Very good. Okay. The ayes have it, and you are granted, 8 months of relief? So you are eligible to reapply beginning on, somebody do the math, it was May 22nd, or whatever the closest business day is to that. Thanks for your time today. Thank you so much. Good luck. Okay.
So you have two more?
Yep. It's a long day.
Yeah, big agenda.
The next case before the board is 2022-016-806B Stockwell Street. This is a special planning district. Special planning districts in the application process for short-term rental property always require review by the planning department. This particular specific plan district is for the purpose of the SP is permit detached accessory dwelling units in all standards of RS5 for primary and accessory structures that are not detached accessory dwelling units. So basically, this was a SP designed to allow occupancy of detached accessory dwelling units. This is governed by Bill 2017-608, and the board has discretion to lessen the one-year prohibition against applying for a short-term rental permit. August 28 of 2019, the owner-occupied permit application was initiated. September 13th of 2019, the permit was issued for the DADU, which is the detached accessory dwelling unit, and not the main dwelling. September 22nd, 2019, the Airbnb website ad was posted. On April 16th of 2020, notice of violation was sent by Inspector John Feltz for permit number not displayed in the website advertisement. The advertisement was corrected within the remedial time period and the case was closed. On September the 4th of 2020, the permit was renewed. On September the 13th you have a typo on your packet. It was actually September 13th of 2021, the permit expired. October of 2021, 5 documented stays. November 2021, 3 documented stays. November 23rd of 2021, the address appeared on the monthly list of properties advertising and operating without a permit or with an expired permit provided by Metro Government's compliance contractor, Granicus Host Compliance, for follow-up investigation. The notice of violation sent by Inspector John Feltz for advertising and operating with an expired permit. December 14th, 2021, the Airbnb website ad changed to a minimum 30-night stay and the case was closed. December of 2021, there was 1 documented stay. February 25th of 2022, the short-term rental board appeal was filed. There were 9 documented stays after the permit expired. There was 1 documented stay after the remedial time period, and there were no documented complaints for the property in either the Metro Hub or with the host compliance hotline.
Great. Anybody have any questions for Metro before we hear from the appellant? Okay, very good. So, Mr. Sulmers, I presume if you could open the microphone, tell us your name and the address where you live for the record, and tell us about your situation.
Yeah, George Sulmers, 806 Stockwell Street, Nashville, 37207. In September, I had 2 family members who had COVID, and I was tending to one of them for the month of September. And then in the time afterwards, I was sort of playing catch up between my child who's got dyslexia, getting her acclimated in school, and sort of like regrouping my life back together. So I wasn't aware until I actually saw the sign on my door. And then once that happened, I took care of it immediately. And the reason why there was a stay after is because when I spoke to Mr. Phelps, he said to allow it to occur. So I didn't cancel that meeting.
I don't have documentation of the conversation or the email.
Right.
However, I will say the indication that I had was that it was after the remedial period. But after reviewing the file, there is a possibility that it did occur before the end of the remedial time period.
And the reason why this appeals took this period of time is because I believe it's Mr. Osborne didn't respond to me for 3 months, and then I spoke to him. I came back in person and asked if there was something I did incorrectly when filing the appeal, and that's why it got pushed up, even though I made the formal request, I believe, in February or something.
Okay. Yeah, we have February 25th of this year as when the appeal was filed. And is that your recollection?
Yeah, but I made the request in December to no response.
Understood. Okay. Can I just revisit with this issue that you were under the impression that you were given leave by Inspector Phelps to go ahead and continue to operate without a permit?
No, there was a reservation that was already booked, and he said to not. I asked him for advice as to how to address that, and he said, allow it to occur.
What was the stated reason for him advising you to allow it to occur?
I assumed it was because the proximity in which the time in which I had found out and the time it was going to occur might not have allowed them. That was the only understood. That was my only.
If we could go to staff for 1 second.
Yeah, I don't have firsthand knowledge of the conversation in this case, but I can tell you that it is not the goal of our department to inconvenience guests. If they're booked and they're coming that weekend, we generally will not recommend it, is provided that it's in the remedial time period. We generally will not inconvenience visitors to Nashville.
So I think that
Good to know.
the important factor there is within the remedial period or not. I think that sounds like what maybe staff goes off of if they make such recommendations.
I'm a little concerned that staff is giving any advice at all to.
Well, but, I'm glad to at least hear this, that if it, we can't know. We can't know, did they find out on a Friday and it's, holy smokes, we got somebody arriving at 5 o'clock today. That's a far cry from, you just keep at it,
Even, it places that stay. It places that stay in the category of a disputed fact for me.
Okay.
So it's a bit hard for me to know what to do with that.
Yeah.
And I still kind of stand behind the proposition that staff. It's not the province of staff to give them advice on compliance-related matters. I think explaining administrative processes is certainly something that makes sense, but the opining on whether or not you should actually honor a stay is. That's tricky for me.
If I may, the remedial time period, if they comply within the remedial time period, then it's considered complied. If this falls within the remedial time period, and they still comply, it's complied.
Gotcha.
And I believe I complied the day I knew, the day I was aware, so I
Sure.
didn't think
Sure,
I
sure,
was
sure.
doing anything outside of the
Sure.
protocol.
Mr. Bond has an issue.
Just a concern.
Yeah.
Just a concern.
Okay, any other questions for Mr. Solmers? Okay. So, correct me if I'm wrong, you still have the property advertised, but right now it's up for a minimum 1-month rental?
Correct.
Okay. Very good.
I do have one question. Did you cancel any other stays?
There were no others after that one. There was only the one, and then I took it off the system.
Okay. All right. If there are no other questions, I'm going to close the public hearing, and we will discuss this amongst ourselves. You can stay there or go back to your seats, up to you entirely, and we'll let you know if we want to ask any additional questions. Okay? What do you guys think?
This is interesting.
Well,
I can't comfortably do anything with the one documented stay because I don't. It's just unclear to me how I should treat that.
Taking that one documented stay out of the equation, though, there's still 8 documented stays after the permit expires.
There are.
Right. I think it's, if we take that one off the table and out of our consideration, I think it's heartening to see, though, that there may not have been any after the,
Remedial.
after the appellant became aware. Oh, go ahead, Mac.
I looked up the notice of violation that was sent, and the advertisement was removed changed to 30 nights on the 14th of December. The remedial time period ended December the 23rd.
Okay. All right.
Okay.
So unless Mr. Solmers had strangers in his dad do for Christmas Eve and Christmas, odds are this stay happened in the remedial time period.
Yes.
So, okay.
So we're still only looking at those 8.
Yeah, I think we're looking at 8. I mean, I think we're looking at, this is an owner who obviously has a vested interest in how this place is run, in that it's in his backyard or above his garage or wherever his detached dwelling unit is. If we kind of operate off of the assumptions that we've made today with some of these cases, he's an experienced operator, but there have been some lulls in the operation. So not as much of a, running this as a business as someone who's running 33. So it was his responsibility, but we certainly can understand what happens when you have sick relatives and kids that are being homeschooled and blah, blah, blah.
yeah, I mean, to me, this is a case of an error on the operator's part, failure to renew. I mean, I think that we understand that. 8 stays, 9 stays total is a lot, but I mean, there was one after notice was delivered to the appellant, and then that even may have occurred. It sounds like it occurred within the remedial time period, so, and possibly with the advice of staff, which I'm going to have a conversation about that too.
I thought you might. Bring Terry.
So yeah, I mean, I'm open to some degree of relief, like commensurate with what we've offered in other cases. I don't have an exact motion. If folks have an idea about the amount of time, or I'm open to hearing it.
I think I'd like to settle on what we would consider our start date for any time period, be it 12 months or 8 months or what have you. I'm comfortable with December 14th. Okay.
Okay.
And and we'll lump that December stay into the remedial time period. I can see Whitney might not agree with me.
No, I agree on that day. I'm looking at it in the context of, even if we're just looking at 8 stays, I mean, he only had 1 permit renewal. I'm just trying to distinguish
Got it.
between other cases
Mhm.
from today in particular. So whereas he had a larger number of stays, 1 permit renewal to me
Yeah.
makes it distinguishable.
Right, in that he's just not particularly experienced.
Correct. So
Until
whereas I
now.
think 4 months is too, I'm Goldilocks, 4 months is too small, 7 months is too,
Yeah.
you know, I think 7 months may be too large.
So 6 months may be just right.
May
I think,
May 14th.
my goodness.
Yeah.
I was gonna say, I was gonna operate from the 8 stays, 8 months.
I don't think we should lock
You
into
don't like,
setting
okay.
that.
Right,
All right,
yeah.
well, that's fine.
Yeah, and I don't-
Because-
yeah.
The
It was
points-
good once. Okay.
It fit once, yes.
Throwing my own ideas out.
I think I'd be comfortable with 6 months.
I would say, and I know I just said I was Goldilocks and said 7 may be too long, but I would say 6 or 7.
Okay.
Because of the number of stays.
I think 6 is reasonable.
Okay. I
think
And
6
that,
is
in fact,
reasonable.
that was the number that popped into my mind when we were first starting to deliberate.
I would like to make a motion.
Perfect.
Please.
Please. So would I. I'll make it.
Oh, I see how this is. I'm just speaking too slow. I'll just draw this out some longer.
Funny.
I would like to make a motion that we penalize with 6 months so that Mr. Sulmers would be able to reapply for a permit May 14th,
Would it not be
or no, sorry, June
June.
14th?
Would it not be June?
December.
February to March, April.
6 months
If we're counting.
from December.
We're
Yeah.
counting December 14th, so yeah. it'd be June
December 14th, it would be June 14th.
Oh, June, yeah, okay.
June 14th.
Start over.
I'd like to make a motion that we penalize Mr. Sulmers with a 6-month suspension so that he can reapply for a permit on June 14th, 2022.
Oh, God, I hate to be this person. If we call it a suspension, it has an entirely different.
Sorry,
yeah,
not suspension.
Yeah.
Third time's the charm, Phil.
Relief of 6 months.
No,
Yeah.
from December to January, to February, to March, to April, to May, to June, that is 6 months.
In the past, didn't we just say a 6-month from the date of December 14th, and then how about we just do that?
6 months from December 14th for Mr. Sulmers. He can reapply.
Second.
Do I see a show of hands on who would like to support the motion to have a 6-month waiting period to reapply for Mr. Sulmers? Very good. The ayes have it. Mr. Sulmers seems to have a question. Do I need to reopen the hearing in order for Mr. Sulmers to ask the question? The public hearing is reopened.
To reapply, do I do it online or in person?
Metro is going to help you with all of that. Very good. Thank you so much. Appreciate your time today, sir.
Rowdy bunch.
It is a rowdy bunch
Has
today.
everybody had lunch yet? No, has everybody had lunch?
We started off
Actually, it's a
We
new
started
moon
off rowdy.
today, I believe. It's either a new moon today or tomorrow.
How do we?
do our motions?
Yes, please.
Yeah.
We need like
A template.
I
All right,
agree-
I'm going to
I
make a
agree.
cheat sheet.
Yeah, I agree. There's definitely,
We also need to, I think Mike's exactly right. We need to stop giving a date and just saying 6 months. Because obviously, we're fuzzy math people. We're way too
Listen,
liberal
I'm an-
arts for all that.
I'm an attorney who does not work in the finance sector. I don't put it out there very quickly that I'm not.
All right. Mr. McBroom's like, let's get on with it.
Well, I would-
Okay,
I would
last
just-
case?
I would just like to say in your motions, if you just say you're granting relief, that's probably the most effective vehicle.
We're granting relief and the number of months, and that's it. Oh, but we should probably alert you as to the date, right? That the start date of the 6-month period, or the 8-month period, or the
Yes.
what have you.
6 months from,
X date. Very good. Okay.
and the last case before the board today is 2022-017, 610 21st Avenue North, number 304. appellant, and obviously no opposition. Governed by BL 2019-6, and the board has no discretion to lessen the one-year prohibition to apply for the short-term rental permit. In this case, the discretion of the board is whether the zoning administrator erred in denying the permit based on the evidence the property was advertised and operated as a short-term rental property after the ownership change prior to obtaining a new permit. January 21st of 2020, a not-owner-occupied permit application was initiated. On January 24th of 2020, the permit was issued. On March 1st of 2020, the VRBO website advertisement was posted. On March 5th, 2020, on March 5th, 2020, a Booking.com advertisement and Airbnb website advertisement were posted. August 15th of 2020, 1620 First Avenue North at number 304 was conveyed by quitclaim deed to Lonnie Ray, LLC. By law, this constitutes a change of ownership. On October the 24th of 2020, Homes and Villas by Marriott ad was posted. On November 4th of 2020, Flip Key ad was posted. There were 7 documented stays after the ownership change in the year of 2020. January 12th of 2021, the permit was renewed in error. There were 35 documented stays in the year of 2021. In fairness, the permit was errantly renewed for that year. However, the property did continue to operate for 16 months after the permit was canceled by process of law. On January of 2022, the permit renewal documentation was received by the Metro Department of Codes, at which time change of ownership was discovered. The following email was sent to the owner, and the email is there for you to read, but it indicates that the permit was canceled due to the change in ownership, and the operation had continued, and therefore the permit could not be renewed.
Okay.
The previously posted website ads were removed by February 3rd of 2022, and the Booking.com advertisement website ad was posted on February the 7th of 2022, which remains posted as of Tuesday, March 29th of 2022, with no reviews. There were 42 verifiable documented stays after the ownership change. The last stay was in early January, as it was published January the 5th of 2022, indicating the stay was completed before that date. There were no documented stays after the owners were made aware of the cancellation, and there were no documented complaints on the host compliance hotline or the Metro Hub.
I have one question. So on the January 12th, when the permit was renewed in error, was that mistake confined to Metro's records, or did a new permit issue to the new owners at the address where they were receiving their mail so that they had it in hand?
Actually, the LLC, it was an LLC that was the previous owner. So they basically, I assume, in an attempt to take advantage of the protections provided by an LLC, changed it to an LLC without realizing that constituted change in ownership, but
Gotcha.
It does.
I'm pretty sure I know the answer to this, but that is spelled out, right, in the application, that any change of ownership does cancel the permit, yeah? In the materials?
There have been different iterations of the affidavit. In fact, the new one, as a result of the short-term rental task group, was recently posted. I can't say with 100% certainty that that was in there at the time this permit was issued.
Okay. I mean, I think it's been in every iteration of the ordinance since the first one. I mean, it's been in the ordinance. It may not be in the materials that the applicant signs when they, or reads when they fill out an application.
I know that recent iterations of the affidavit that is in the permitting process do have that there, but again, I can't say with certainty as to whether or not when this permit was issued that the affidavit reflected that.
Okay. Very good. Any other questions for Metro? Mr. Waters? All right. Come on down.
Eh.
Mr. Waters, I presume.
You have
In that
no
you're the
idea how
only
badly
guy-
I wanted to say correct as usual, Uncle Friday. I held back.
Okay. You know the drill by now.
I do. Where's the red button? Where's the button? Is it the little speaker guy up here?
Yep, exactly.
Patrick Waters, my address is 5412 Stonebox Lane, Brentwood, Tennessee, 37027. Sorry, I'm nervous and my voice is cracking, but that's fine.
You are fine.
Basically, we're here, look, some mistakes were made. When we purchased the condo, which it's an industrial place, it is a commercial property. It was supposed to be put in an LLC. My mortgage broker quit during the purchasing process, so the person who filled in for him just didn't know and put it in our name. We immediately, when we got it, asked them to switch that, which they did, and we didn't know. That's it.
Okay, Mr. Waters. You're okay. Does anyone have any questions for Mr. Waters? He's going to take a minute.
Sorry.
You're fine. You were fine.
I have a question.
Go ahead, Ron.
So what I'm hearing is you owned it, you've owned it. It was just the name change.
And as far as we can tell, there have never been any documented complaints, right?
No.
So this was just, let's go back to the beginning. This was an investment property that you bought. It was erroneously put in your personal name instead of the name of your LLC. But it appears that you applied for and received a permit before you ever advertised the property in the first place.
Yes.
Which is refreshing, I can tell you. Even those who come to us and know they've never done anything wrong, very often we see that the ad was posted a few weeks before the permit. And that never seems to come up in conversation, but I always take notice. So thank you for doing that. So, and I apologize, I don't mean to call you out, but you seem very upset. This has been trying, obviously. Yeah. Yeah. Do you own any other investment properties? Nope, just this one?
And I lost my job, and it's just,
Okay. We totally understand.
and, I sought out to get the permit this year, just like I did the year before. And it was renewed the year before, and we just,
Yep.
you know.
So can I just confirm, there were, the argument is technically, there were all these stays made after the change of ownership, but it's just technical change of ownership. Have we had any, what did you do when you got this? This was just January 25th that you got this email.
I notified the management company immediately. They removed all the ads. I actually had to do it twice because my management company sold on February 1st to a new one, which is why that Booking.com ad is still up, which is infuriating. But they rebooked a bunch of dates, which I had to cancel again. And then we just went through the process and did what we were supposed to do, did the letters and the sign and all those things. So.
Okay. Does anyone else have any questions for Mr. Waters?
I have a question for staff.
Yeah.
Is that
Mr.
appropriate to
McBroom?
do now, or should?
I think that's okay. We're still in the public hearing, right? Alex, that's fine. Yep.
Thank you, Mr. McBroom. So, can you tell me a little bit about to what extent Metro reviews whether there has been, does Metro review by course whether there has been a change of ownership upon permit renewal for each permit?
Yes. In fact, it's been the practice for quite some time to do so. we're all human. Occasionally we miss things. It's obvious from the renewal letter that was sent out in this particular case that it should not have been missed, but however it was. Nonetheless, in each of these cases, the cancellation by process of law occurs as soon as the ownership transition is completed with the financial institution. That is the ordinance, and it is also the opinion handed down by Metro Legal, which I'll be happy to retrieve and read to you if you wish. I have it here.
Thank you, sir. That answers my specific question.
Okay.
So,
I can add, though, that I accessed the permitting application. The affidavit did not indicate the ownership change as
Very
being a
good. That's
violation.
great to know. Thank you so much.
So, I have a question, and I guess this is partially for legal counsel or staff, whoever is most knowledgeable, or if the information can be ascertained quickly. So I'm curious about the legislative intent in sort of specifying that any time that a permit is transferred to another person or entity or individual, what was the legislature? Get my bodies right here. What was the council thinking when they actually came up with that provision? Were they envisioning a situation like this where a pair of individuals were simply transferring an asset that they previously owned into a more advantageous legal or financial arrangement, or whatever the basis was for the transfer? Is that what they mean when to another? Actually, when they say to another, is that what they're referring to?
I will say that, I can't speak to legislative intent of council, but I will say that for most Metro permits, there are limitations in transfers because Metro needs to be able to review each permit holder to have the affidavits to check to make sure everything's appropriate. Sometimes there's limitations on whether or not a person can have a criminal background, and so that's a general Metro prohibition on transfers, just to allow us to review and understand who's owning the properties that we have.
Okay.
Sean may be able to add some color to this too, but I seem to recall being involved in discussions about what these ordinances were going to look like over the course of the years. I think the stated intent I heard from council members was that the goal was to not have certain properties as permanent short-term rentals. You know, that if company A bought it and made all the neighbors miserable and sold it to company B, it wasn't just carried on in the same fashion, that the new owner would have to start from scratch.
Right.
So I think that truly was my understanding. If the goal was to keep certain properties from being permanently deemed as short-term rentals, then the Waters case really does not comport with what that intention was. There was a transfer of ownership technically,
Right.
but the operation was consistent.
So, yeah, I think that's fair. And I was not on the Metro Council when 608 was formulated, which I think is where this came into play. I'll say that, the way that my thinking on this is sort of, like in Wilson County, it's basically a business permit you get to run an Airbnb. You wouldn't sell someone a commercial building and say, unless they buy the business, and in that case, the business would need to get properly permitted and everything else. It would just not be assumed. So, I think it is a reasonable thing that we do. I think that if you've watched meeting after meeting at BZA, when these cases were still happening there was a lot of this, what constitutes a transfer? Is it an estate? Is it a divorce? These things. And, in this case, I don't know how much back and forth it's appropriate for us to be having a discussion while the public hearing's still open, so I might save my thoughts for a moment.
My question's answered.
So if we are going to try to wrap up the public hearing, if anyone else has any questions for Mr. Waters?
Yes.
Mr. Waters, are you and your wife the only members of the LLC?
Yes. Yeah.
Thanks.
Yeah.
Excellent question. Okay.
I have a situation. I have a trust, and when I moved from Chicago down here, anyway, they were finally updating it. Well, they wanted me to, the legal guy says, change it from the Ron Hogan Trust to the Hogan Family Trust. My property's in the Ron Hogan Trust. So if I change it to the Hogan Family Trust, I have to change all of my property.
Yeah.
Back to that. It's the same thing. It's the same people.
Yeah.
And I would have lost, I used to have a short-term rental permit. And I would have lost that. So, I mean, I see it as I hate to say the administrator erred, but I think in this case, I think we can say that he didn't take that into consideration, and I would.
I think this is appropriate for our internal conversation.
Right.
Shall
Yeah,
we,
right.
shall we wrap up our questioning of Mr. Waters? To hold that thought, Ron, I'm just going to close the public hearing unless we have any more questions for Mr. Waters. Okay, let's consider the public hearing closed. And I'm sorry, Ron, please finish your thought.
No, I just, I think it's just it's a matter of, he just didn't look at it. I mean, he looked at, it does look like, you're changing ownership, but if you read all the background and get all the knowledge that they're the same people, it's not a transfer to another entity. It's basically, the entities are comprised of the same.
Yeah.
Yeah.
The use of the word another, to me, connotes that, there is a separate and distinct individual or entity that is transferring ownership into. So with that said, I'm comfortable actually finding that the administrator did err in this case because there was no change of ownership within the meaning of the applicable code provision.
I'm not comfortable with that. I think that there was, we moving a property from a natural person to an LLC, I think that what gives me comfort with deciding that an error was made here, and actually I wanted to ask a procedural question for legal. Do we need to, what is the implication of this body making a determination that the zoning administrator erred?
I mean, there's not, first of all, it's very regular determination for BZA. I think the one concern here is that you have what you're able to flesh out here in your board meeting is not the kind of information that staff will necessarily be able to obtain. They're not going to have someone sit in front of a mic able to essentially be under oath and with a discussion. So the staff has to stick with a set of guidelines, and if they see a change in ownership that's not associated with something direct like a divorce, our office has opined a little bit differently about divorces. But if it's something like that, they pretty much have to reject it. And then you have the opportunity here to flesh out things like this. If you reduce your opinion, if you reduce something based on something you've learned here, I think you have the discretion to do that. But it's not necessarily a finding of error. Right. As much as it is, you're able to learn some different information.
Absolutely.
But do we have the discretion to reduce the time period in this one? Because it's governed by 2019-6.
Right,
yes. Yep, so I understand the question a little better now. Yes, I don't think it's a finding of error for what the zoning administrator did. I think they correctly Metro Legal would tell you that unless it's related to a divorce, our opinion is if the name's on before and then there's a divorce and one name remains but the other is gone, that's not a change in ownership. But anything else would be an effective change in ownership. And again, you got to remember it's very difficult to figure out when LLCs change or other different businesses change, who the actual members are.
When you have two people that are sole members of an LLC or a legal entity, and they were the owners before, I don't feel like that analysis holds up.
I think there are public policy implications for the fact that you cannot allow someone who is an owner of a property to freely be able to transfer their property into an entity that provides them more protection.
Yeah.
I understand exactly why, based on the historical perspective that we have talked about here today, I think there is gray area in this. I think it would be my recommendation that Metro Council tries to tighten this up some, because I think that this has the potential to unfairly penalize someone who has essentially done nothing wrong, to be able to put himself in a better legal position as far as managing his own finances and his own risks.
I agree. I just don't think this is what the council had in mind when they were talking about changes of ownership. ownership.
I think for me, I'm leaning toward whatever determination, whatever motion would allow the appellant to apply as soon as possible. And largely that's because the permit was issued in error and they operated for a year. I think that this is unusual circumstances. I think if we want to have a bigger discussion about the rules around transfer of permits, we can, but I think in this particular case, because of the particular set of circumstances here, I'm going to be supportive of allowing them to apply tomorrow morning or when they walk across the halls.
I don't know, if we can make a detrimental reliance type argument and say because they made because, codes made a representation affirmatively to these people that they actually had I don't know. I feel like it's less of a stretch to say the change in ownership doesn't fit within.
Right, they relied upon the issuance of this to their detriment. But what I'm struggling with is I'm with you, Sean, 100%. What I'm struggling with is the governing ordinance at the time saying that we don't have discretion to lessen the one-year prohibition. But do we have discretion to say the permit that was renewed in error, we can't, they can't be penalized?
We're assigning that the status of a zoning administrator error, and that's just not what it is.
Yeah.
No, but if you go with a detrimental reliance argument, which I think is excellent terminology for this particular scenario, that the detrimental reliance stems from an error from the zoning office. So my motion is.
Can we hear from legal?
Yeah, I will say that the law on incorrectly issued permits is that detrimental reliance is not a substantial factor in that. I hate to say it, but codes misses permits sometimes, and we have to go back. The idea being that where's the greater pain on someone who is had to rely on a wrong permit to build something, or on a clerk who essentially changed the law. And so our position is that the detrimental reliance aspect wouldn't be appropriate. But it's your board, you can do whatever you want to do on that.
Well, one question is what would legal, to the end that it appears this body is interested in achieving here, is there a motion that legal could feel comfortable with?
Well, you could find that the zoning administrator acted in error. So that's the only way you can really get out of it.
I move that the zoning administrator acted in error.
I second.
Do we need to include that the appellant can apply?
He can apply right now in my motion.
Seconded.
Can we see a show of hands? Okay. You're
Thank you, sir.
all set. Thanks for coming in. We appreciate your time. Take good care. I feel like a little rebellious after we just did that.
I don't.
Okay.
I don't at all. I think that the law creates, I think there are gaps sometimes.
Yeah.
I would okay. The ability to refund the fee and the appeal fee too. $700 and something.
Oh, is it?
Because the original fee that was erroneous.
Did you get your checkbook on yet?
I know. And 409 for today.
Wow. No wonder he was crying. Poor guy. Okay. So, the hearing is closed. Thanks, everybody.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.